bury her. I mean, how many celebrities have been buried in Hollywood?
You're absolutely right.
Hi friends, it's Mir from STARSPOT USA. Welcome back to my channel. It's Tuesday, April 15th. It's taxes day. Make sure you get your taxes done if you haven't yet already. And we have some answers here about what Wayfair parties are going to do when it comes to their amended complaint, which last week the judge said that he would not extend a deadline for the amended complaints till 21 days after he rules on the motions to dismiss, and he also refused to extend a deadline on discovery. And because the Wayfair parties are deep in discovery at this time and working on answering and getting documents to the lively parties on the other side of the case and the Stephanie Jones parties. On the second lawsuit, there's a lot of intermingling lawsuits happening. There were some questions about what were they going to do? Are they going to stand down on the comp complaint they have and be confident in what they've submitted, or are they going to potentially sort of give in to the doubt that's been seeded by the opponents in this case, or the defendants, the co-defendants, about what they believe are the issues with the complaint? So plainly speaking, was Wayfair going to admit defeat and say, oh yeah, they had the right arguments, we were wrong, we need to fix this? Or else we're going to bet dismissed because they're right. Their arguments are right. Ours are wrong. And strategically, they could have done a tone of two ways. They could have given in and admitted defeat and said, yeah, we had some fatal flawed arguments here. Other hand, they could have stood down, and today they've made a decision. They're going to stand down, and instead of filing a motion for leave to amend, they sent a letter simply notifying the court of what their decision was. And they said that we write to notify the court that the Wayfair parties do not intend to move for leave to amend after pleading by the April 18th, 2025 deadline set forth in the case management plan and scheduling order. The Wayfair parties stand behind the operative first amended complaint and are confident for the reasons outlined in their opposition. Briefs dockets 12-1-1-27, 160, and 162 that currently pending motions to dismiss will be denied. If the court were to grant one or more of the motions to any extent, the Wayfair parties will move for leave to amend pursuant to Federal Rules of Civil Procedure 15A2 and seek to commensurate modification of the scheduling order under the good cause standard pursuant to Federal Rules of Civil Procedure 16B4, consistent with guidance set forth in. And then they cite three separate cases, which is one that was ruled by Judge Lehman, which is Furry Puppet Studios versus Fallout Boy. Another is Sacerdote versus New York University. And then the third that they're saying would help them with their good cause to show. Good cause is Espeland 2018, Partners LLC versus Mount Howie Inc. Company. So the three cited cases they say would be analyzed for applying application of good cause standard for a motion for leave to amend. So what does this mean? Well, strategically, this means that they're showing that they're competent. They believe that the arguments that they've given to the court are valid as to why these motions, their complaints, should not be dismissed. They believe that the motions to dismiss cannot pass in the grounds and the arguments that have been made by Lively, Reynolds, and Sloan in the New York Times, and they're not giving in to this idea that what Lively and Reynolds and Sloan have said is factual, or that their arguments that they're going to be using with the judge are going to work in terms of getting the cases thrown out, and they're standing firm in what they've pled in their cases, and they're standing firm in how they've argued against the motions to dismiss. And quite honestly, if you're Justin Baldoni, who has been accused by some of the people on the set of kind of being the guy that kind of was a pushover and really sidelined himself in some ways because he would hand over the reins a lot and let other people lead, and he wants to take everyone's position into account, and he wants to let everyone have a voice. I mean, that was some of the feedback from crew, is he can be a little bit too diplomatic sometimes, and he sometimes gives people too much power, and sometimes can appear like he doesn't know what he's doing, even if he does. And Justin has said that about himself as well. So in one way, it's kind of being the opposite of what he's been accused, right? So he's saying no, I'm not going to listen to all that noise, and I'm going to be confident in this. And it's also saying to the judge, no.
Opportunity, we have a responsibility to take care of a book that means so much to so many people.
We feel like we did a good job, and you shouldn't buy into their motions to dismiss. So the three separate cases that they are actually claiming, and what these little rules are saying is basically if the judge were to grant any part of their motions to dismiss, they're going to seek permission to amend their pleadings, and they're going to use Civil Rule of Procedure 1582, and that allows for amendments with the court's leave when justice so requires. because such amendments would likely impact the current schedule. They will also request a corresponding adjustment to the scheduling order under the good cause standard set by Rule 16b-4 and what they're going to use for. The basis of their request is the Furry Puppet Studio versus Fallout Boy, and that provides guidance on when amendments and scheduling changes may be granted together. They're going to use another case called Sacredote versus New York University, which interprets the Second Circuit's position on leave to amend after Rule 16b. And then, the Espinal 2018 Partners versus Mount Hoadley specifically analyze the good cause standard, how it applies when a party seeks to amend after deadlines have passed. So they're going to use these three. And the interesting thing is, the Fallout Boy one is actually, again, something that Judge Lehman, that's his decision. And so it's kind of like, we respect your decision. So the reliance on the furry puppet is because it deals with interplay between rules 15 and 16 and emphasizes that even when Rule 15 would favor the amendment rule, 16 good cause standard must still be satisfied. And then the Sacredote one is looking at what the Second Circuit Court has upheld with this analysis. And then the third case, that's a more recent decision, and it indicates that what they're going to do is be more grounded in what the current district is interpreting and how they're interpreting leave to amend. They're preparing in a sense that parts of this could be dismissed. It's like they're playing offense, but then they have a defense ready. They're confident, but if they need to, they already have the plan set up. So it's like strategy of what they're going to do, because this is a letter just notifying the court of what their intentions are. Lively's people don't need to respond. They might, but they don't need to. It's just a notification. It's no different than when Lively sent a letter notifying if she was going to file a motion to dismiss, which she did. I think this justice a good move on their part. I think amending is kind of giving in again, like I said, to the bullies and saying well, you pointed out what was wrong, so I'm going to fix it. And this is just basically being confident to the judge and being ready for anything. We're confident, but we're ready and prepared to do what we need. We'll have to wait and see. Again, I don't know. The judge in this case has been doing orders really fast. Quite honestly, I wish I had a judge like this in one of my cases who's waited months to rule on basically every motion we file, but that's state court versus federal court. But he appears to be motivated because I think so much of this case is being tried in the public, and I think so much of this case has become PR and a PR war between the two sides. And as more evidence of that and why he might be more motivated to work on these petitions and these motions to dismiss, I'm going to share with you something that Stephanie Jones filed in court, which is honestly, I'm baffled by her decision here to file this in court with the fact that Stephanie Jones is seeking to dismiss Jen Abel's third-party complaint. Okay, so Jen Abel is trying to get Stephanie to be liable in the event that she's held liable for anything that she did. And then also saying, I was your employee, I was working under your direction and your loyalty and your obedience and your direction. And also saying that the contract she signed was invalid and she wants to nullify it under a California law. Now Stephanie Jones, being Stephanie Jones, is coming in with her dukes up. And to be clear, Stephanie Jones had her own issues with her business. And Jenna Ale is not the person that caused her issues. Okay, Jenna Ale is not the agent that created the culture in Jones. Jen Ale worked in the Los Angeles branch. Stephanie had branches in New York and LA, and Stephanie had a lot of clients leave. In 2024, she lost huge clients. She lost Dwayne "The Rock" Johnson. She lost Amazon's Jeff Bezos and his fiancée, or ex-fiancée Lauren. And then she lost major corporations that were companies that she was working with PR, for she also lost Chris Helmsworth.
Very complicated job. You have to hold the entire vision of the movie in your head and then find ways to communicate it.
Okay, so she was Los. She lost really big names in entertainment. Really A-list celebrities, Dwayne "The Rock" Johnson was the highest paid male actor in all of 2024. He exceeded Ryan Reynolds because Ryan Reynolds, I think, was second because of his Deadpool film. But yeah, so she lost huge players. And for her to try to pin the article of what happened with the Business Insider article on Jen, it's kind of like Blake trying to say that people don't like her because of Justin, instead of Blake actually taking accountability for what she's done. It shared the clip from 60 Minutes Australia with this specific PR agent that was interviewed to say sometimes the best thing to do in a crisis is to take accountability. And he was talking about it from Justin's perspective, right? But The same could be said for Blake. She had her own crisis that she was dealing with, and she could have taken accountability by apologizing for the perception that she was downplaying victims. She could have done that. There was no reason why she didn't have to, and she could still today do that, and some of this would stop. But the problem is, she's kind of pouring salt on a wound, and for her to suggest that it was Justin that fed that narrative, she's underestimating the people that read the book and how big the book was. You're talking about a book that sold over 10 million copies, that was on the New York Times bestseller list for 100-some weeks or more, that's not going to be an easy film to walk into because it has high expectations. And people have a lot of feelings about what the book meant to them. It was a very important book for survivors of domestic violence that felt like their story was told through Lily. So they're the ones that had the loud voices. And so if she apologized to those victims, that they feel offended by how she marketed it, could go a long way. So when it comes to Stephanie Jones, she wants to dismiss Jen Abel's third-party claim. And when she is filing this motion to dismiss, she's doing something really weird by first having a preliminary statement, which is weird, then providing a background, then getting into an argument. And the preliminary statement actually introduces things that are not a part of this case, nor are they part of the four corners of the complaint that Jen Ale filed against Stephanie Jones. Nor is this evidence part of Blake Lively's amended complaint, nor is it part of Justin's amended complaint. And you can't technically go outside the bounds of the four corners of these complaints when you file a motion to dismiss. And because we know that some of the screenshots that were shared by Stephanie and by Blake lacked context, I think it's important to remember that Stephanie has a habit of only sharing words, one sentence out of an entire paragraph, and making it sound like that own sentence is what was said, without context. Okay, and the way that she speaks about Abel in this way, I think, is unnecessary in a motion to dismiss, but there we go. She says Jen Ale went rogue Ruth and ruthlessly pursued her own career advancement by leading an aggressive smear campaign and pinning it on her employer. Jones works while contemporaneously seeking to take down her employer by spearheading a Business Insider hit piece against the company and its CEO, Stephanie Jones, stealing confidential documents, poaching clients, and seeking to ruin Joan decade-built reputation, all before the dust had time to settle. Okay, so that she's saying here that none of that is legally sound based on the complaint that she's bringing in. This is all defense. Like, those are all things she could use Asher defense, everything she just said there for why she could win the case. It doesn't work in a motion to dismiss. I just want to be clear. Her plan nearly succeeded until Jones Works caught Eel red-handed executing her treasonous plan. That is serious words by stealing confidential. Company files on her way. Out the door, Jones Works promptly terminated her for the theft, disloyalty, and replete contractual violations. No having been unmasked as the puppeteer behind the smear campaign and facing lawsuits that seek to hold her accountable. She hid from Jones Works, which she didn't hide from Jones Works. They knew about it the whole time. And engaged in a well outside the purview of her employment. Abel brazenly seeks indemnification from the employer. She betrayed and sought to ruin. So here's the thing. None of that was necessary. And if she wants to get her point across, she doesn't have to be this disgusting. But again, the verbal insults are going back and forth on both sides. So I have to be fair with that. But Stephanie Jones, to act like Jen was the only one involved in that Business Insider is ridiculous, because it included, they spoke to dozens of people and ex-clients, and her accounts of Jed and Wayfair don't match.
I made the allegation, you can't fight me back or sue me back. I mean, it seems like that's what she's implying.
What Wayfair and Jen say. So it's kind of he said, she said, and Wayfair is adamant that Jen did not take her or take them or steal them, but Stephanie says that they did. So how did if Stephanie says you stole Wayfair and you made them choose you and Wayfair? It's like, no, you didn't do that. That didn't happen, Stephanie. I don't know how she stands to prove that. Given that Wayfair claims that they chose to go with Ale because they trusted her, she brings in screenshots evidence that wasn't a part of the amended complaint. Okay, she brings in answers and counterclaims, and she uses dockets from cases that are in the other case that's not joined to this case. I don't think she can do this. But she brings in a screenshot from August 7, July 29th saying it's Melissa Nathan to Jennel saying, I know, and once you are gone, we'll be on accounts together and make really good money and be happy. And then another one from Melissa Nathan to Jen AL on August 9th saying, let's just keep it steering that way, and then take this effing client and never talk to her. Again, I swear to God. And then she brings in 2 more screenshots from August 13th that are again not a part of the evidence, and she's citing another document which says Jennifer AL telling Melissa. Nathan, on the 13th, we are going to war, and I feel so alive. And then she brings in another document or another screenshot which says on the 21st of August, by the way, I'm having my offboarding this morning with our chief of staff because staff won't face me, and you should see the list I made of things to bring up. And then she said she was going to hold them hostage, and it's wild. And this was sent at, I don't know what time. And again, I don't know when. She says Abel admits that in parallel with the action for which she now seeks indemnification, she and Nathan were encouraging Wayfair and Baldoni to breach their contracts. And then she uses the same text messages in two different arguments. But Nate, she brings up another screenshot from Melissa Nathan and says, I'm just going to step out of line before I go to bed and tell you Jen is amazing. She's so loyal, she loves you so much, and you have to go with her. And she's like, oh my God, of course I'm going with her. Okay, they're claiming that they admit to starting this before, as early as July 29th and through August 9th, when she was communicating with her co-conspirator Melissa Nathan on their evil scheme for her to leave Jones' work poach, clients and profit at their expense. And there she's citing Jennifer Abel's answer to complaint counterclaims and jury trial demand. Abel's answer to Jones and Abel counterclaims docket 36 Jones versus Ale filed in March 20th of 2025. I don't know. That you can bring in some evidence from another case into a motion to dismiss. So what Stephanie Jones is doing here is kind of cherry-picking the answers that Jenelle made in her response to Jeff to the lawsuit filed against her. And it's that she admitted that she received messages from Melissa Nathan, or that messages contained her name, but she denied that the communications are being, the context and the characterizations are accurately portrayed in Stephanie's complaint. So she's basically saying, yes, received that, but it's not in full context, essentially. But Stephanie, on her motion to dismiss, is trying to claim that, this is some sort of admission that she admitted to doing this same thing with the quote, unquote, she says with the shakedown of Jones' works, which she says is answer 102, and she admits the allegations that she and Nathan sent communications containing this text set forth in that paragraph. They deny all remaining allegations in the paragraph and specifically denies that the communications and their context are characterized accurately in the complaint. So the splicing and dicing defense, essentially. So for her to bring this in, I don't know if the judge will even consider it, but none of these text messages, at least a few of them, have never been revealed. By Stephanie, okay. Especially the one about how she's going to be going to the offboarding meeting, or that, they're encouraging them to breach the contract, which is in contrast to what actually Wayfair says. She brings up stuff like trashing Wayfair behind their backs. None of this is relevant at all to a motion to dismiss. And what she's bringing up are issues of fact. I think that a judge can't determine in a motion to dismiss. What she's, I think, trying to tell the judge is that she lacks credibility.
When my physical therapist enters, he looks like if Zac Efron and Fabio had a baby.
And that she's misleading the court by stating that she was working in concert or for Jones' works, and that she's misrepresenting that she was being held against her will in false imprisonment. But I don't think that a judge would want to make this decision in a motion to dismiss because, again, was the count pled correctly? Did it meet the pleading requirements? And if there's an issue of fact that has to be either managed through summary judgment or through a motion to, or at trial, either way, she brings in a lot of these salacious text messages that I feel if you are Stephanie Jones and if you are a client of Stephanie Jones, I would feel really uncomfortable personally knowing that if you get on her bad side, she's going to take the messages that you sent while you were working for her that were supposed to be confidential about a client, and then use them to publicly humiliate you and smear you and try to hold you into a certain light that may or may not be true. Okay, I feel like all this is doing at least for me. If I were to be a client, I'd be really skeptical to want to be her client. I would be afraid that if I did leave, she would try to smear me and take me down for betraying her. And I would be worried about working for her and based in how she treats her ex-employees. It almost kind of confirms what the Who is afraid of Stephanie Jones' article was, saying about how she retaliates against people, but she wants it thrown out. She says that she went in defiance of the instructions. She was doing it for her own interests and not for Jones' works. She brings up that she could not have foreseen that its trusted senior employee would betray it, which is weird because she put in her resignation in July and she's acting like she has nothing to do with the Balon case. Right now, everything that's been pled in court are allegations. None of this has been verified as fact. No one's agreed on facts yet. So because she's saying Jen said this or Jen said that, it doesn't mean it's a fact. And it feels weird that she would want to bring in the other documents, because if she's going to open that door, then the judge could look at Justin's complaint, right? And see that he references this Business Insider article. The judge can go read the article himself and see that it wasn't done by one person. And she can't prove outside of like Jen speaking to this reporter about Jones, beyond that she said she spoke to him in a text message. And quite honestly, what was reported in that Business Insider document was an abusive, toxic, hostile work environment, which under the law, an employee has a right to report. I mean, here's some allegations from that article, just to give you some insider. She would regularly turn on deafening music so that she could berate her employees free from scrutiny. One former employee said, "I don't think there was one day in the office that someone wasn't crying." Another one was that she would call people when they took sick days to verify if they were sick. And a tone person that formerly worked for her said that they were at a funeral, and she called them on FaceTime while they were at a funeral to verify they were at a funeral. There was really high turnover. She seldom allowed people to leave the company, amicably, often enlisting attorneys to threaten and intimidate them into agreeing not to disparage Jones. It says that April, Dwayne "The Rock" Johnson dropped her after there was a clash between Jones and Johnson's team. It was a huge loss when she lost them, and then she lost Bezos, Sanchez, Lainey Wilson, Chris Helmsworth, Wheels Up, Ocean Spray, and Partake Foods all in the span-off, like a little over a year. Either Wayfair is doing a really amazing smear campaign through their complaints, or Stephanie Jones really is just this volatile person that will take things out of context and use them against people, right? So Stephanie's motion to dismiss. I will get into more detail, but I just want to say, I think it's wild that she would try to introduce this evidence, and I think it would be easy to see some of the things that have been said in these cherry-picked sentences, but without knowing what she was fully saying, what the following statements were after, whether or not things were said injusticed or sarcastically, we don't know. And Stephanie can't really introduce new evidence into a motion to dismiss. And we don't see how a judge can say, well, we haven't even really verified the facts of this case yet for me to decide on this being dismissed. But it feels like Stephanie started all of this, and now she wants to get out of all of it. And she wants to be with Lively suing everyone because of it. And yet somehow Jones is trying to pretend like she doesn't know anything about it, even though she does. It doesn't make a lot of sense to me. So what are your thoughts about all of this updated information about Wayfair standing down?
I mean, honestly, I didn't have any hesitations. To me, it was a no-brainer.
Justin standing down and saying, "We're going tossed in by our complaint," and about Stephanie Jones going bananas and putting in new screenshots that are completely lacking context in a motion to dismiss that is supposed to be about legal issues within the complaint of law, not of fact, and what a judge is going to think about that. I can't wait to see what the reply is from Wayfair. I'm sure it's going to be that she's bringing in evidence that's not admissible into that part of the motion to dismiss.